Removal of maritime claims. Removal is a term that applies to a defendant removing a case from state court to federal court. Maritime claims may be brought in either state or federal court. The federal courts have original jurisdiction, constitutional grant codified by the Judiciary Act of 1789. We also have the savings to suitors clause, which provides concurrent jurisdiction of the state and federal courts. Seamen's injuries claims may not be removed to federal court. With the passage of the Jones Act, Congress gave to seamen all of the rights that the railroad workers had under the Fela, the Federal Employers Liability Act. Under Fela, railroad workers have what's called forum privilege. They may bring their claim in either state or federal court, and it may not be disturbed. Fela cases are persuasive in Jones Act cases. The courts interpreting the Jones Act have adopted Fela's forum privilege, and Jones Act cases may not be removed from state to federal court. The defendant that seeks to do so faces a very high burden. To successfully remove the seaman's injury claim from state court, the Jones Act employer must show that the Jones Act claims were fraudulently pled, and there is no way, no possibility that the seaman will be able to make out his Jones Act injury claim. The federal courts, we have trial courts, the appellate courts, and then the Supreme Court of the United States. There are 11 circuit courts of appeal, and they don't always agree. And there's a difference between the Fifth Circuit and the Ninth Circuit. The Fifth Circuit applies to maritime workers working on the Gulf Coast in general, and the Ninth Circuit to those on the West Coast. In the Fifth Circuit Court of Appeals, they have adopted a summary judgment-like procedure that allows the employer to put on evidence in a summary proceeding to prove that the case was fraudulently pled. However, in the Ninth Circuit, the Jones Act employer may not pierce the pleadings. The court will typically make its ruling based on the four corners of the complaint. This law firm has a published opinion from the District of Oregon, Liloff versus Georgia Pacific, dealing with this issue and which standard to apply when the Jones Act employer is attempting to remove the seaman's case. We successfully argued to the court that the pro-seaman approach, which does not result in one of these summary hearings, is the better approach, and that is currently the law of this circuit. Defendants often seek to remove a Jones Act or other maritime injury case to the federal courts, invoking the federal court's diversity jurisdiction. If they can show that the defendant and the plaintiff are residents of different states, and the amount in controversy exceeds $75,000, there is a basis for jurisdiction and removal to the federal court. Defendants prefer federal court out of concern of being hometowned in the state court. The idea is that the judge and jury may be biased against a global shipping operator or one that resides in many states, and they are inherently biased in favor of the injured plaintiff who is from the hometown. Federal court is generally more expensive, has different evidentiary rules. For these reasons and others, defendants seem to favor it for fear of being hometowned.